Thank you very much. Good afternoon. Can you hear me okay? Can you hear me?
I can hear you. I can hear you at least. Thank you, sir.
Great. Okay. Thank you very much for the introduction. Yes, I'll go straight in. As you heard, my name is Kenny Wright, and I've been working with Ms. Ketevan on the project in relation to IPR enforcement. The presentation is split into 5 sections. The first section is why IPR infringement should be a priority for law enforcement. I'll then give in point 2, an overview of the IPR enforcement activity Ketevan and myself have been working on. We'll then touch on 2 of the sections in that activity, the comparison with the legislation and the comparison between the practices. And finally, Ketevan will conclude the presentation by highlighting some practical problems in the Georgian system and talk about one of the proposed solutions to help with those problems, IPR enforcement guides. So to start, just very briefly, because Mikhail has said quite a lot on this already, why IPR infringement should be a law enforcement priority. I'll just concentrate on 3 reasons. Number 1, the economy. Number 2, organized crime. And number 3, health and safety. So prior to 2013, we had no idea about the value of intellectual property to the European Union economy. And then, as you heard, the EU IPO and the European Patent Office came up with a methodology, and they published the first study in 2013. That study is updated every 3 years, and the latest study was published in 2019. And here are 1 or 2 of the main findings. Number 1, nearly 30% of all jobs in the European Union are in IPR intensive industries. That's nearly 63 million jobs. If you add in the industries which support the IPR intensive industries, we are closer to 40% of jobs, and you add in another 20 million jobs on top. Down the right-hand side of that slide that you're looking at, we break down the contribution by IP object. Time is short, I won't go into detail, but of course you can see this report online. When you come to GDP and you look at IPR intensive industries, nearly 45% of the annual GDP in the European Union, the entire European Union, all the member states, come from IPR intensive industries. That's 6.6 trillion euros every year comes from IPR intensive industries. So as you can see, IPR is a cornerstone of the European Union economy, and therefore it is a priority for us to protect it. At the moment, we do not know the value of IP to the Georgian economy, but I suspect it will not be much different from what we found in the European Union. Just one more thing to add, jobs in IPR intensive industries are high quality jobs. They pay on average 47% more than jobs in other industries. Consequently, these are the type of jobs that you want in your country. So it is a priority to protect and enforce intellectual property rights for the economy. Okay, number 2, let's look at organized crime. Now, once more, the EU IPO and OECD have worked on calculating the value of the illegal trade in fakes every year. You heard from Mikhail that in 2019, the latest figures we have, the value of the illegal trade in fakes is up to $509 billion a year, or roughly 420 billion euros. Now, that figure only includes goods made in one country and sold in another country. It does not include goods and services made and sold in the same country, and it does not include the internet, because quite frankly, the EU IPO and the OECD did not have the statistics for the last two categories of crime. So these figures only include goods or services made in one country and delivered in another. So let's compare it to other criminality that you can see on the screen there. At the left-hand side of the screen, you can see the value of the illegal trade in small arms. Then we move up to art, to timber, to wildlife, to oil, to the trade in humans. And the second most valuable illegal trade in that chart is the trade in narcotics. But the number one most valuable trade, illegal trade in the world is in fakes, IPR infringements. Organized crime is all about making money. We accept that it's involved in every other trade on that chart. So why should they ignore the most valuable illegal trade in the world? The last thing is health and safety. Another reason why law enforcement must make IP crime a priority. The criminals behind the fake trade, the manufacture of counterfeits, do not care about the health and safety of the consumer. They are only interested in maximizing their profits. One example on the screen, this was a young lady from Denmark. She went to Thailand. She spent her first day on the beach. She got a lovely suntan. She went back to her hotel. She discovered she forgot her after sun lotion. She went to the local market in Thailand. She saw the brand that she recognized from back home in Denmark. She bought it. She went back to her hotel. She applied it to her skin, and she ended up with third-degree burns. She is now scarred for life. The criminals that manufacture that cream do not care. In order to make that cream, that fake cream, that counterfeit cream, look more like the genuine item, they added acid to the ingredients. They do not care about the health and safety of the consumer. And finally, once more, as you heard from Michael earlier, there was a meeting just last month of the EU Council of Ministers, and they identified the top 10 priorities for fighting organized crime in the European Union. And they included intellectual property crime in those top 10 priorities. So in the EU, we now recognize that it is essential that law enforcement priorities the fight against IP crime. Okay, we move on to number 2 in the agenda, and just a quick overview of the EUGIPP IPR enforcement activity. Now, in the activity, we have several tasks, and I'll just list the 5 probably most intensive that we've been involved in. Number 1 is to develop an overview of the Georgian IPR enforcement system. Number 2 was to do a comparative analysis between the EU acquis and Georgian IPR enforcement legislation. Number 3 was to do a comparative analysis between EU best practice and the Georgian IPR enforcement system. Number 4 concerned drafting legislation, so making the legislation stronger to assist the IPR enforcement authorities protect and enforce intellectual property rights. And the 5th section or action that we're doing concerns the IPR enforcement guides, which you will hear more from Ketevan at the end of this presentation. So let's just concentrate very briefly on the findings of the comparative analysis between the EU acquis and the Georgian IPR enforcement legislation. So in this action, in this section, Ketevan and myself, we looked at the border enforcement of IPR, civil enforcement, criminal enforcement, online enforcement, and administrative enforcement. Two things I'd like to add here. When it comes to criminal enforcement, the EUGIPP does not have any directives or regulations. We only have Article 61 of the TRIPS agreement. And then the second thing to note, when it comes to administrative enforcement, there is nothing in the EUGIPP concerning administrative offences relating to the infringement of intellectual property rights. However, many of the member states do have administrative offences, and we use Croatia in our comparison in this exercise. So very quickly, some of the major differences that we highlighted in our report when it came to border enforcement of IPR. In Georgia, you are yet to develop a small consignment procedure. So the number of goods that are fake goods, all goods, but in particular fake goods, now coming through the postal system or the courier system has grown and grown and grown over the last 10 years because of the internet and ordinary goods on the internet. So to help customs enforce intellectual property rights at the border, in the EU, we've developed a streamlined system. And we would encourage Georgia to do something similar so that it will help customs enforce postal and small consignment packages containing fake goods. The second discrepancy we noticed is in the EU, we now have a procedure in place for dealing with goods which infringe trademark, but are in transit through the EU, not going to land in the EU. You do not have something similar in Georgia, and we would encourage you to do so. When it comes to civil enforcement, right to information, that is that a right holder can go to the court, obtain a court order to force the seller, for instance, of fake goods to disclose the origin of those goods. For some IP objects, you do not have, or the civil courts do not yet have that power in Georgia. Just some IP objects like geographical indications. The second thing I wanted to note when it came to civil enforcement was corrective measures. So in the European Union, the courts can order the destruction, the recall from channels, and the definite removal from channels of fake goods and the tools and machines for making those fake goods. You have still to put something explicitly in your civil enforcement legislation, and we would recommend you do so. When it comes to online enforcement, liability of intermediate service providers in the EU, we have made it crystal clear that the ISPs are not liable for infringement until they become aware of it. And when they become aware of it, then they must act expeditiously to stop the infringement, otherwise they become jointly liable for the infringement. In Georgia, you have yet to develop something similar, but I know there is draft legislation in the pipeline that will be adopted soon. And lastly, when it comes to online enforcement, injunctions, civil injunctions, court injunctions against intermediaries, you have it for some IP objects like trademarks, but for others, geographical indications, you have yet to develop, and we would encourage you to do so. Okay, very briefly, criminal enforcement of IPR. The TRIPS agreement mentions commercial scale. So goods or the infringement of intellectual property rights becomes criminal when it's a commercial scale. That has been interpreted to mean just to sell goods. So for instance, a small quantity of goods sold from a shop could be commercial scale. But your legislation, for instance, in Article 196, you say that in order for it to be criminal, there must be over 1,000 items, or the value must be over 5,000 of the local currency, the Georgian currency. We would recommend that perhaps that threshold should be relaxed a bit, and we will discuss further during the activity. Last thing, deterrent sentences. In order, the TRIPS agreement is very crystal clear that sentencing must be a deterrent, and we're not quite sure that that is the case in Georgia, that deterrent sentences are being given for the infringement of intellectual property rights. Administrative enforcement, two ingredients I wanted to highlight here was, once more, the right to information. So in Croatia, if someone is selling, for instance, fake champagne, then the administrative authorities can ask the seller to disclose the origin of the goods. You do not yet have that power in Georgia, but we would, of course, recommend you do. And then once more, deterrent sentencing. We would recommend that people involved in the manufacture, the distribution, the sale of fakes should be scared of what will happen to them if they are caught and it goes to court. Right, moving on to the fourth section of this presentation. And again, it's one of the actions we've taken in the enforcement activity of the project. And it's a comparative analysis between EU best practice and the Georgian IPR enforcement system. And again, I just want to highlight 5 or 6 subjects for you to consider. Political will. So, but before the establishment of the observatory at the EU IPO, it was very hard for me to recruit politicians and the senior management of IPR enforcement agencies about the importance of fighting IP crime. And with the work and the establishment and the subsequent work of the observatory at the EU IPO, we now have lots and lots of studies showing the value of IP to the economy, and also the loss of IP infringements, fakes, crime to the economy. So now I find it a lot easier to convince politicians and the senior management of IPR enforcement agencies that they should prioritize the fight against IP crime. You have yet to develop such studies and reports in Georgia, but I would encourage you to do so. Second thing is dedicated IPR enforcement units. It's very, very important that IPR enforcement units concentrate their daily work on enforcing intellectual property rights. And they're not distracted by fighting other crime. So you must have a well-resourced, both with manpower and equipment, dedicated units in customs, in police, in your market inspectors, to make sure that they are dedicated to fighting IPR infringements. Third thing to underline is enforcement organizations must be able to use covert investigation techniques. We will never stop the sale of fake goods by just arresting the seller. We must be able to move up the supply chain to identify the distributors, to identify the manufacturers, to identify the financiers. That's the only way to make an impact. And that is, in my experience, a law enforcement officer, you need to have the power to use covert investigation techniques, such as wiretaps, to go up that supply chain, to identify the Mr. Bigs at the top, and to seize their assets, the reason why they're in this crime. Fourth point I'd like to make concerns voluntary collaborative practices. Mikhail mentioned one there, shipping companies. You must create a good relationship with shipping companies so that they assist you in the fight against the fake trade. But it's also equally important to work with the intermediaries involved in the internet service providers, the advertisers on these illegal websites. You, as law enforcement officers, as government, should be working with these industries to develop practices that help you disrupt the business models of the fake trade. Finally, when it comes to best practice, I would like there to be an IPR enforcement strategy, a dedicated IPR enforcement strategy that covers everything from strengthening the legislation to raising awareness of consumers about the danger of counterfeit and fake goods to getting more powers for law enforcement. That should all be included in an IPR enforcement strategy. Thank you very much for my time. I'd now like to hand over to Ketevan.
Thank you very much, and I'd like to give time to Mr. Samson Uridia. If Mr. Kazimierczak is online, Mr. Samson has question for him as well. Thank you very much, Mrs. Nino, and many thanks to Mr. Kenny Wright for this comprehensive presentation, and he properly highlighted how important it is to work with the Customs Department, and customs enforcement is very essential. I have a specific question for you. According to legislation, we have a special law on custom but it does not refer to small consignment that is placed in handbag of a traveler. Also, we had undertaken a commitment under AA that I'd like to highlight, that we do not have any provision on small consignment that is placed in handbag or luggage. And do you mean other small type of small consignment or the small consignment that is placed in handbag? Also, another question for regarding transit. You are well aware that transit has a very complex nature, especially when we do not know the IPR scope in destination country. Therefore, we have very pressing challenges to contact IPR holders timely. And is it realistic for us to include transit in border enforcement activity? This was my questions for you. Thank you.
Okay, thank you very much for your questions. Number one, when it comes to small consignments, I'm referring to consignments that come through the postal or the courier system. So not in the luggage of a passenger, for instance. So in order for a consignment to be defined as a small consignment in the EU regulation, then it must be come through the postal or the courier system. It must be 2 kilograms or less in weight, and there must be 3 or less items in the package. And if it meets all those criteria, then it can be treated as a small consignment and be put through the expeditious process that we now have in the EU for the detention and hopefully subsequently destruction of the goods. So I'm not talking about luggage, but goods that are in the postal or courier system. When it comes to goods in transit, yes, not easy. Of course, it has been a subject of great debate in the EU for many, many years. And the legal text we've developed recently concerns only goods infringing trademarks. And basically, if customs were to intercept goods in transit, which they believe will of course still be infringing in the country of destination, they can of course detain it. It's then up to the owner of that shipment to prove to the court that the goods are not infringing intellectual property rights in the country of final destination. So there's a reverse presumption on the owner of the goods to prove to the courts that a transit shipment will not infringe the intellectual property rights in the country of final destination. But of course, in the project, we will go into more detail with you. We don't have real much time to discuss it in detail here. But I hope that answers your 2 questions.
Now we can proceed with the following component from this presentation. Very warm greetings. I do understand that we are behind the agenda, and I will try to be very brief. There were two main topics I'd like to cover, and my overarching objective is to cover practical problems as well as IPR enforcement guides and future steps that should be implemented within the framework of this project. I will not dive into details regarding practical problems, but I will put emphasis on future steps. As Mr. Khan highlighted, our common goal was to identify to do comparative analysis between EU acquis and the Georgian legislation in order to find drawbacks and flaws. And Mrs. Nino mentioned that our legislation more or less is in compliance with the EU regulations. However, still our country needs to make certain amendments in the legislation. In addition, the second component of the project was as follows. Despite the fact that everything is okay in legislation and the components are in fully harmonization with EU one, so another question arises here: how EU acquis is implemented in reality? What kind of challenges we might have while implementation and enforcement of these components. I personally met all agencies responsible for implementation, and as a result of these meetings, we developed certain list of challenges. Some of them will be tackled through legislation, and another part does not need to make amendment in legislation, but it requires certain guidelines or recommendations, and these guidelines and recommendations will be very helpful to each agencies to put specific terms, differences into practice. As a result of this meeting, we have identified that we have different interpretation of provisions. Also, there were different interpretation of court decisions. In some cases, judges interpreted the provisions differently. To be very short, there were different type of interpretations of this provision of legislation. For example, meaning of other illegal use, as well as meaning of entering into civil turnover. Judges made different interpretation regarding these terms and definitions. After our meetings, we identified certain challenges and we made the decision to have additional definition apart from legislation. And this additional meaning or definition will be very helpful for relevant stakeholders to better enforce IPR. Consequently, one of the components of project was to develop guidelines. We considered it would be better if we develop these guidelines separately for customs departments, because there were debates to develop one common document consisting of different guidelines, or to develop separate documents or papers for different agencies. But we are keenly aware that customs have has different procedures, and monitoring agency has different procedure as well as different regulations. Apart from legislation, there is a decree of Minister of Finance. Also, in terms of criminal enforcement, prosecutor's office and investigation service have their own different regulations. So So we agreed on to develop procedures or guidelines separately for customs department, for tax monitoring department, as well as for investigation, because investigation consists of pursuing investigation as well as some procedural activities. Also, we made this decision to develop these guidelines and recommendations separately. And as for the common practice, this common practice exists in European countries, USA and Canada. These documents or papers do not impose any additional obligations on any executing body. This is manual or guideline that is very helpful for procedure implementing or investigation service to implement IPR activities properly. We have developed the first draft. And we are currently at the stage where we are making certain clarifications with agencies. With their indulgence, I will take this opportunity, and I'd like to kindly ask to each agencies to be very open and to assign, designate, or to design to assign a specific individual for further communication, and through communication with this responsible individual, we will be able to develop better recommendations and guidelines for this agency that will be very helpful for this agency specifically. This is my goal, to tell you that I am the person to give you a helping hand in your activity, also to simplify your daily work.
We'll be working on the changes of the legislation. And if we think that there is no problem in some direction in the legislation, but practically some norms are wrong in practical terms, and we will correct it in the guidelines. Thank you very much for this opportunity. If you have any questions, I'm ready to answer. First of all, I would like to echo to the Samson's comment. Of course, I agree. Nowadays, we have the mechanism when the stakeholder refers to the revenue service concerning entering some object into the intellectual property register, and maybe the special requirement will be considered with this application, which will refer to the transit, and the company might have the option to react to the important as well as the transit goods. And if the revenue service notification is not heard or replied, then we will extend the existing measures which are entered into the law. It's just on the level of it was just my opinion. It could be the solution in these conditions. Of course, I understand that control of movement of the transit goods is related with many difficulties, but I would like to emphasize that currently, in terms of the geographical indications, we have better reactions by the law enforcement structures, and I hope that we will have resources to extend our activities. I am happy that Katie intensively worked on this issue. But as this panel will be over today, I understand that Katie already identified some problems in this area, but I should take an opportunity and raise some problematic issues which exist in the working process. And I would like to tell you about that because we don't often have the luxury to see the law enforcement structures and revenue structures, revenue service representatives in one space. You know that this process has been going on for years, and now I will shift to the specific issues. The number one, which was mentioned by the colleague, it's information concerning the counterfeit sources. I know the position of the revenue service when the administrative procedures are held. The counterfeit goods identification. In this process, the revenue service currently proceeding from the legislation does not have the luxury to start the deeper investigation on the issue to find out where the origin, the source is. And the idea is that maybe we will provide the revenue service with the opportunity to do that. Maybe some legislative changes are necessary by some laws and so on. You know, the current situation is not efficient. And the state resources, public resources aren't spent efficiently. You know, we have just one step to the finding the truth. Maybe it's in 100 meters, but we cannot do that. And finally, what do we get? The retailer can take the goods and put them on the market. We have to refer to the revenue service, bother them, and they should assign the resources and so on. It will be much more rational if the revenue service has this authority to find out the origin, the source of the goods. Another issue refers to the time limits, because you know that counterfeit goods, especially in the household chemistry area, very often is collected very quickly in the retail network, and it's quickly sold, you know, and for understandable reasons, the revenue service cannot respond to in 1 or 2 days. So they, according to the law, they have the 2 months time limit, but very often, I'm not saying that they react in a month, but at the level of the legislative act or bylaw, if it's depicted there, the game rules will be much better described there, and it won't depend on the revenue service resources. So maybe we should indicate the shorter time limit. And lastly, Katie mentioned, and I should express concern that recently we refrain from appealing to the revenue service because we don't know what will happen on the court. And you know, probably you're aware of that. We can talk about it later. I can tell you that the essence of the issue is that revenue service defines the law violation act to the retail trader and takes it to the court, and then the court says that it does not find any violation. We know that revenue service resources are much higher than our resources, but we are ready to get involved in this game in order to at least get the clarifications from the court what to do in such cases. And other cases related to the investigation service, they refer to the time limits. We understand the situation, but it's fully unpredictable. Maybe at least at a practical level, it will be possible to clarify these issues when we refer for some issues to the revenue service, and our foreign clients ask us, in which time limit should we expect the results? no reply. We don't have any reply because it depends on the pace of the investigation. And if we can bring some clarification to this issue, I think it will be much more comfortable and understandable for the local as well as foreign right holders. And another thing refers to the intention. Maybe there are some novelties planned because concerning the imported goods, very often the investigation service has a problem of proof of the intention, unlike some other countries, which probably have the constructive intention system. Maybe it will be reflected there. What somebody can say that I went abroad and bought the Samsung mobile phone for $25 when it actually cost, I didn't know it costs $1,200. You know, we can prove that he's lying, but actually it's not reliable and it's not persuasive. Thank you. All of the issues listed by you are identified, including the meetings with you. I know that you had some other issues listed, but you didn't name them. We work on all these directions concerning the goods source. I agree with you. And in case if the revenue monitoring department has the resources, it might be arranged with the internal regulations. It does not require any legislative changes. Do you know are you aware of their position on that? They're present here. Concerning the time limits, time terms, it's a problem. I agree with you that tax monitoring department has 1 month term, and in the month this section does not even make sense. And in terms of the patent attorneys, I would recommend to make amendments to the order of minister in order to change the mechanisms. And we should take into consideration the resources of the tax monitoring department to react in short term in this direction. But we're working in this area, and I hope that we will agree on something specific which will be acceptable and it won't burden the tax department too much. As to the court practice, judiciary practice, I cannot promise anything. In the same format, they will be discussing this issue. I know that you are very concerned about this one issue. It's novel practices from the court when they ask for the conclusion of the independent service in order to prove that these goods are counterfeit. It doesn't happen in any country. And we have seen the practices of many countries, and anywhere the right owner's conclusion is quite sufficient to prove that these goods are counterfeit ones. But we should continue communication with the court and there is an entry in the administrative code which says that the court for the court, the proof is only the conclusion issued by the independent person, and the right owner cannot be considered as such. And another code is so obsolete that we cannot even change it. It's shameful. So we should find some way, some solution for arranging. As to the time terms of the investigation, I personally worked for a long time in prosecutor's office in investigation, and I know that determining any kind of deadline and saying that according to the Article 196, investigator should investigate it in 1 year or 6 months, it's impossible. It's also unimaginary to say that to define some time terms for specific categories of cases. You know, it might, but I think I know how popular this idea is, But if I was a decision maker, I would say that the investigation of these crimes should be conducted by the investigators who don't have any other cases under proceedings. It must be some kind of specialization, which would arrange the problems with the time terms as well as some other investigational problems. I don't know if the financial police is ready for this decision, but as idea, I can offer as a experienced investigator and former prosecutor, I can say that although those crimes are almost similar, it's very hard to say which case will be done earlier or later. And we should accept the statement of the investigator that he or she does not know when the result will be obtained. As to the intention, we talked about this. In the legislation, we have the problem that intellectual property, the crime against intellectual property right, we cannot define the intention for separate formulation. For example, the intention for the murder is different and for trademark use is different. My personal recommendation is when I worked on the identification of these problems and the elaboration of recommendations, including the guidelines on which we're still working. We should elaborate some mechanisms which will help the investigator to define the intention, to define that the person who, for example, sells the counterfeit goods, the investigator should have the proof that the person knew that it was the counterfeit goods. And there are some mechanisms for that. We talked with the investigators on this topic, and I hope that in this direction we will also have some progress and interesting offers from for the investigators. Also, I think the experience of our EU experts will be interesting concerning how they define the intention, existence of intention. You know, we can see the different European judiciary practices, what mechanisms are used. I know that in Georgia, it's very common to send the letter according to which we have the proof that that person is informed that he's selling the counterfeit goods, so that the prosecutor and investigator had some proofs and they were able to accuse the person. Maybe it was not very understandable for not investigators and prosecutors. And Minister of Finance investigational service, maybe they will also offer their opinion. Greetings. Thank you, Georgi. I would like to touch upon Katie's issue. The interpretation problems are in the practice. You brought the examples of the different interpretations. Maybe you meant the transit, but we deal with the interpretation by the court. So for investigation, the service, the elaboration of the guidelines and the telling how to interpret it, it won't be helpful. We should know how to reach consensus with the court, and we should elaborate the uniform approaches. And we can say that these terms should be interpreted practically this way. Otherwise, we cannot do anything with this explanation of the court. And to corroborate, I will bring one example. When we were working on the instruction concerning the monitoring department, we said that the expert conclusions should be brought. But initially I was also protesting, saying you aren't independent, you aren't subjective. But I was persuaded that the world practices are the same. You know, but it's written in the normative act. But anyway, you know, the order of the minister is a normative act, but it's not anyway persuasive for the court. But how do you think will guideline help this issue? You know, but administrative law violations code says that proof is necessary. I understand that you are angry with the court. Maybe I will also be, I am also angry a little bit on the judiciary, with the judiciary, but I agree that source of the problem could be the non-homogeneous explanation of the court. We will try to adjust the legislation as required to the maximum in order, you know, I will recall you, we offered, and it was written in the instruction, that the signatory of the conclusion will be criminally liable if that conclusion is false. And I also offer to take into the consideration in the instructions the financial liabilities of the right holder. The right holder on behalf of whom the signatory is acting, he also will be liable. I think it will be another mechanism for excluding the ruling out the wrong conclusions. Greetings once again. The issues raised by Georgi are concern for us as well. We discussed them on different meetings, at least part of these issues concerning the investigation of such type of the crime. And Katie already talked about it, and we also talked about it with the investigators, raised the issue of the confirmation of the intent. But elaboration of the procedure, as Katie said, after which the investigator might say that this, and this are present and the intention is present, it will be hard. The only solution is obtainment of more evidences and elaboration of the guideline for the investigator, how he will be able to find more proofs. I think it will be more practical. And I don't think other way will be justified, because the judiciary principles for all kinds of the crimes are similar. As to the issue of the independent expert, we also discuss this issue. The prosecutor's office, the investigative service, and we have what? The proof, evidence or conclusion, and even it's signed many times that he undertakes the criminal liability for false conclusion. But the investigators know very well that the conclusion of experts, the expert conclusion is just opinion, and it's quite hard to initiate a case against somebody or start prosecution of somebody for conclusion, because always the expert conclusion is a subjective opinion, and he can always say that he thought so. And what do we have? We have the expert's conclusion, and that expert is actually the affected party, and it creates this standard. If we're oriented to improve the investigation of such kind of the crime and have the stronger evidences, we need the expert's conclusion. And our position was that maybe under SAC Patente or some other agencies, there would be the independent group which can provide the conclusion. The financial liability maybe within some administrative procedures will be assigned to the law violator, right violator, but I think such kind of agency will be the best solution for everybody. For example, we were saying that when we investigate the cases of tax avoidance, the investigator cannot give the conclusion that some entity avoided that amount of the tax. This conclusion is given by the specified agency, the auditor, and then this conclusion is critically discussed, reviewed by the investigator. How relevant and correct is it? And such kind of analogy would help us with arranging all the problems, and it would help with creating the evidences. As to the time terms of the investigation, I cannot add much to Katie's opinion. First of all, the investigator wants to investigate the case faster and shift to another case, and if the investigator has some reasons that it does not go fast, it does not mean that he has more time for something else. No, it's more time consuming. And the time terms are related with many circumstances. And in case of Georgi, it's not the case, but sometimes the low activity of the patent attorney is observed when the first communication or interview with a law violator happens later. The patent attorney does not come to contact anymore, and it prolongs the time to. And it will be hard to imagine the legislative mechanisms of changing the situation. Irakli, tomorrow we will have an opportunity at the exhibition to show you the counterfeit and original products, and maybe we will return to this conversation tomorrow. We are talking about the manufacturer standard, and the counterfeit is identified through the outside visual signs, but we have the knowledge from the manufacturer, but they don't tell everything as fully, and whatever they tell us, they say sometimes don't disclose this information, and the expert won't be the expert on all kinds of products. He should listen to the holder of the copyright and make conclusions if his position is corroborated. And we aren't talking only about the trademark use, also the copyright violations. When the copyright is violated, when my book was published by somebody, I'm not talking about that. Here we talk about the scale of the damage, and the affected party proceeding from his interests might be exaggerating them, or he maybe thinks that the potential damage will be much higher. And the criminal investigator cannot be aware of everything. His first obligation is to comply, to conduct the evidences obtainment procedures. He should listen to the patent attorneys and finally take decision if there is any violation or not, and what is the scale and what is the damage. Thank you. Unfortunately, we exceeded our time too much. although the discussion was extremely interesting and very interesting issues were discussed, and we saw once again how important it is that all the actors of the process, which means the rights enforcement, should be in the same space and commonly find some solution and identify the problems which we're talking about. I think it's very good that we have the opportunity within the framework of this project. And many issues were raised, which in my opinion, this area in Georgia is kind of toddler making the first steps. We have a long story. We did much in order to make some steps forward, but in some issues, we are still at the stage of finding out. So within this project, the fact that EU is involved and we're discussing the issues where we don't have to invent the wheel, and we should also consider our reality of the legislation to which we should adjust. But proceeding from the specifics, we have the approaches, the practices, which actually we can adopt and introduce and cooperate within the project. And later I will ask the experts that to utilize the resources provided by this project to the maximum extent. I didn't have time to provide my presentation. I would like to emphasize that on the initiative of SAC Patenti in 2016, the coordination board, which comprises all the agencies which are related with the rights enforcement. Unfortunately, due to pandemics and some intermediate stages, that functioning of this board was a little bit slowed down, and we should activate its functioning at least in such format, in format of the board. We should raise the issues, initiate, defining some priorities. And I think we will be much more effective. It was one issue, and I wanted generally to talk about legislative changes which were already introduced, and it's in the procedural law, the changes of the procedural law and intellectual property area. Unfortunately, the objective reality is it's a very specific direction, and when from the civil viewpoint, the procedural norms or actions are talked about, there was the need to add one more chapter or part in order to indicate the specific regulations, referring some time term issues or some other approaches. And also it will be possible in the investigative or administrative law part also use the specific approaches, and based on then elaborate the sub-laws or some legislative norms. It was briefly what I wanted to tell you. At this stage, we still have this afternoon and tomorrow, and with the framework of them, we will be able to talk in more detail on these issues. Now we can have a break.